uh, suggestions of Justice Junaid Saab in respect of the winding up of the matter, liquidation of the matters, and finally passing of the dissolution orders. It is indeed important to note that liquidation matters, winding up matters are taking long time, and that is the reason that parties as well as the creditors, they all are ruling. What we have noticed in KP or Peshawar High Court, that these cases are only fixed on Mondays, and there is always a long list of cases of more than 110 or 120 cases, and these cases are always taken up for hearing at the final cases of the day, and that is the reason that the progress is very slow. And another reason is also there, that is in respect of the non-serious attitude of the SECP. They are not properly assisting the courts in the matter, and even certain times notices were issued against them. That's why they are not properly assisting the court, why they are not appearing before the courts. So the matter needs to be resolved at the SECP level, that let some proper person be assign the duties to properly assist the court in all these winding up matters and pending matters of liquidation. I still remember that the oldest case on the diary of the Peshawar High Court is of the earlier PPC, Pakistan Paper Mill Corporation, which is still pending, and that is of the year 1990. And the final order could not be passed due to the lack of interest of the parties, the objectors as well as their counsels. So this is high time, and I think this symposium would play a great role while providing an opportunity to the high courts, as the company benches, as well as the parties and SEPC and their representatives to properly assist the court into the matters. Thank you very much.
Now I request Honourable Judge from the Balochistan High Court to say a few words.
Thank you very much, Mirza Sahib. With permission of Honourable former Chief Justice Tassakud Hussain Jailani Sahib. First of all, I am thankful to SECP for inviting us in this symposium. But here I can say some reservations, and in other words, you can say our gilas. Yesterday, the Balochistan was not given proper representation to address the audience. This we have noted, and seriously we have noted it. The reason best known by the SECP, we don't know. Be that as it may. We have got such experience yesterday from the audience as well as today. Here I can say in Balochistan we have 4 company judges working as company judge. Honorable Chief Justice, I am myself and my colleague Justice Rozi Khan Badech Sahib and Justice Gul Hassan Tareen Sahib. But here we were surprised that till date the non-serious attitude of the, as mentioned by my learned brother Sayeed Atiq Shah of Peshawar High Court, that till date, for assistance of the courts, the SECP has failed to appoint any prosecutor. From here you see the seriousness and seriousness of attitude of the SECP. Even there is no proper representation from the official side. Only one assistant director is coming and taking the notice and forwarding the same to their headquarters. So the Balochistan is facing too much problems, and the company judges are facing much problems for assistance because of lacking in numbers of corporate lawyers in Balochistan. And the Balochistan will be the future of Pakistan in forthcoming days. As you see, there are many foreign investors are interested to invest in the Balochistan. So we need proper assistance, we need proper shares, and we do expect from SSCP. The SSCP will take this matter as serious and appoint prosecutors, and SSCP can repeat such like symposiums in Balochistan. And we will appreciate this, and we will manage, and we will cooperate with SSCP. Thank you very much.
Sir, I'm so grateful. आपको पता है कि मेरा ताल्लुक पाकिस्तान से है, मेरी 2 generations, और I'm sorry for any regret, लेकिन हमने चौधरी साहब
You
को
couldn't play your role. So I'm
yes,
sorry
sir,
to say.
I'm strengthened by your comments. Why? Because yes, sir, we don't have any representation. The law department doesn't have a prosecutor in Quetta or Peshawar. That's unfortunately your emphasis. You very rightly pointed out, and it empowers me to now ensure that this thing is, and that is one of the purpose that we are here. I mean, Lordship. Comments are well taken, and this is recorded, and we will ensure that this is done. It empowers the Chief Prosecutor to tell the Commission that this is now necessary, and this is a comment, and we have to do it.
I'll expect.
Yes, sir, inshallah. Jawad sir, Justice Jawad, 2 few words.
Good morning, Honourable Judges. The topic of the company code rules are alien to me because I am labelled as an anti-winding up judge. I passed some judgment which Supreme Court has appreciated and also brought into a system which was discussed, and also Jameel Khafar Sahab mentioned that in one of his judgments when it went to Supreme Court. His issue is that company code rules has some issues and challenges, but you need to have a full-time judge, you need to resolve this issue, because in Lahore High Court we have lots of COs we dispose of in Pindi bench, at least 4 or 5 a week. We are with the approach to have the anti-winding up approach. Reason was that when I was given the company law cases, I was very much astonished to see that companies were wound up with these vulture liquidators sitting on them, and company was running concern by the, as Justice Junaid Jafar Sahab mentioned that they were by the banks. So one of the very famous cases, which are reported cases, which now cited all over, is Chenab Textile Mill, which are the mill which supplies to Chenwan, a company with 40 billion rupees, running concern, where 15,000 people working for them for 5 crore rupees by the Bank of Saudi Park. They wound up that company. When they wound up that company, my judge bound out, there were 2 liquidators sitting there. I had to resolve under 313 a concept called commercial immorality. The concept of commercial morality, the concept that the Supreme Court upheld the winding up order. Still, I had courage to pass a judgment by giving details and bringing the 22 banks consortium to resolve the issue was only unable to pay debt. When the company came out with the application 313, read with 418, we entered company law, and we develop a concept that if you give an affidavit and you give all the surety to the cause of winding up, though company was wound up, it was a dead company, court can make it work. So that model successfully was then, we developed that further jurisprudence in Pindi, in Al-Qaim, their citation is 2020 CLD 339, and the Pindi bench was further there, that what we do now is, any company which SCCP is bringing to wind up, this was SCCP's petition in Pindi bench was Al-Qaim Textile, where we brought an affidavit by the person, and their commitment to SCCP and their meeting with SCCP. Finally, I dismissed the winding up petition on the ground that the reasons mentioned under section 301, if I complied with, the company, both companies which were saved have tripled their capacity and have more plants. Then most cases in Pindi bench, last week we did 2 cases like this, and Mr. Kamar Afzal, the senior most commercial lawyer of Rawalpindi, Islam, was sitting here. He brought a very famous case in which I was sent to Pindi only for Morga Valley case, which was pending since 1982 by a Dutch financial institution against Morga Valley, and there was a winding up order made in 1997. That still we resolved the issue, they got the money, and after the winding up again, the matter was disposed of under the company code rules in 1997. Those jurisprudence of anti-winding up was how much tax were you paying, how many employees were you employed, how much export you're doing. Most of the companies are coming up with that we are 10%, our input of 10% of Pakistan export is up by us. So those elements were looked into by the court carefully under certain pieces of company law, under the preamble of the company law, was then finally, alhamdulillah, accepted by the Supreme Court of Pakistan. 6 orders passed by my brother judges in Lahore High Court of winding up, all were stayed on the first date by the Supreme Court of Pakistan. That no, he suspended the order of winding up, company shall be going. The re-spilling case, a lot of cases like this. So this is new regime that if a company can be dead, the courts can make it, because as you say, company judge under Section 5 and under Section 6 has more power than has a High Court constitutional judge. My constitutional judge is controlled by the Supreme Court judgments, but in the company law, is just a company judge is so powerful with his own regime under the company law, you can make it happen. And my last suggestion would be that in my full court meeting, I suggested that we should have a full-time judge, because there are 120 COs pending even in courts to have a full, because there are winding up cases, there are liquidation cases, there are COs, it's 86 section, 286. There are a lot of cases every day for a full-time judge. Like we should take an example from London Commercial Court, which did established 100 years ago. Now they only focus 9 judges of High Court were brought to a Rose building, sit as full-time commercial courts. They got a very good reputation. 80% are the foreign users coming to London Commercial Court because of safety, speedy, effective, trusted mechanism. And if in our full court, we suggested Chief Justice of Lahore High Court to have 1 full-time judge only devoted to commercial matters. There's only so many commercial matters. We established commercial courts in Punjab, but we think other courts should adopt that as a full-time judge. Thank you.
Thank you very much, sir. I have another an important announcement to make. I think we have to break as soon as we get the information. Chief Justice of Pakistan has to arrive here, but we need the special branch, needs the venue to clear it. So we'll break for as and when we get the news. We'll shift to the other room for a tea. Sir, thank you very much for your comment. It's always well. Sir, expected is 12 o'clock, but the special branch first informed us that they need it around 11:30. But we're in contact as soon as they, and I think because of the interest and because of the, I mean, there's a lot of people who would like to speak. We'll also adjust time. I think we'll extend our time to 2 o'clock.
Maybe we can have a break 5 minutes.
जी जब वो हमें करेंगे तो वो हमने इसीलिए स्पेशल 7 वाले रूम में टी का इंतजाम किया. So we can easily go there and we'll have tea and they can. Sir, इसमें I'll now include Haider Waheed, another moderator, Haider Waheed and Khuzam, बल्कि first Khuzam. Khuzam, I think हमारे पास तो सबसे ज़्यादा जो cases आते हैं merger, liquidation is from your esteemed law office. So please say a few words. Mike. Talk about the creditors winding up. This is very important that the banks have this option, and I know for sure, I'm in practice, that the creditors now, when the banks are not able to get a good order from the in a banking proceeding, recovery of finance ordinance, they now tend to go to the High Court for winding up of a company. So,
but I'd like to first address an observation Justice Your Lordship made. That is in regard to the sanctioning authority to be shifted to the commission. I understand the law is already drafted that manner. But as a practitioner, when the court sends to the SCCP for comments, they're obliged and they give various comments. Often we are able to convince the High Court that this comment is not warranted. There's a large number, there's a lot of judicial precedents and rich history in this field, and that comfort will be taken away. So if you know, it would make me extremely nervous if at this stage some of the very complex amalgamations, it sometimes takes 6 or 7 months to structure a deal. We research the case law thoroughly, looking not only in Pakistan, India, England, and we come up with a structure. And we want to be innovative to facilitate complex restructurings. And I do believe at this current time, as a practitioner, it would make me very nervous if I do not have confidence that if there is an issue, I can, I'm not a litigator, but my litigation team can plead to the court to see the merits of what our position is.
Mr. Kurema, my observation was only to the extent that courts have been burdened. Now, if we look for a matter of convenience and your worries, then perhaps for you and most of the people, courts would be the right forum, especially for an advocate. But the question here is not your satisfaction or our satisfaction. It is only that we are being burdened first, and then I also made an exception to it. The law is already there. They have just made a provision, and perhaps that was the understanding that would be a temporary basis, and subsection 8 was incorporated. Secondly, as I said, that if there are disputes and there are complications as to legal resolution to resolve disputes, then it can always come to court. I was just talking about especially reduction of share capital issues and simple amalgamations and other related things, and the law has provided that. If they change the law, then it will be decided by the courts, naturally.
And you're a very seasoned lawyer. Almost, if not every week, every month, you file a winding up or a merger or a taken over petitions. Now, my question is, how many petitions have you filed where a very intricate, complex question of law was raised? I'm sure you would say none. Merger petitions for amalgamations are normally decided after they being matured. They decided on one hearing. So why would you burden a court for your convenience that you are comfortable in approaching High Court rather than approaching the tribunal or some offices of the officers of the SCCP? So the jurisdiction cannot be given for your convenience. The tribunal will be equally competent, I'm sure, and your cases will be more efficaciously and expeditiously decided, having a forum within the hierarchy of SCCP, as we have in federal tax cases, tribunals cases, income tax, customs, for instance, and we only see references arising out of some intricate questions of law. So jurisdiction is not conferred for the convenience of the councils. It is really the dispute that would create a forum for its resolution. And merger petitions, amalgamation petitions are not disputes. They are already ripe to be merged as an entity. So I have passed a few judgments as far as the merger petitions are concerned. I don't find any intricate question to be resolved at the stage of High Court level. That can conveniently be done. So submerge your convenience and see the better side of it. We'll have a lot of time for the resolution of your disputes in relation to other complicated matters. Thank you.
Shafiq Sahab, the reason is that SCCP always brings out some kind of observation. You don't call them objections. They always in mergers. There's always most of the things which we are deciding now at Lahore High Court is they bring out lots of observations and some objections to the mergers. So we have to answer those.
How many objections have we taken care of and have not overruled? Most of them. The only question is,
Yes.
I see there are three kind of mergers: the vertical mergers, horizontal mergers, and the conglomerate mergers. The last two mergers, that is the vertical and the conglomerate mergers, the difficulty that I faced was that it is the emerged entity will be governed by the memorandum and article of association of an emerged entity, not of the two. Like, let's suppose if a textile industry is being merged with the cement industry, will the memorandum and article of association of a cement factory can tow the object of a textile industry? So these kind of very technical questions are being sent to us to be looked into. Now, I don't see High Court judge sparing time for these issues. These are not to be adjudicated at these levels.
I'll just inform the audience that rightly said, the SCCP is already managing mergers with respect to small size companies and wholly owned companies of the government. We recently ordered, Pakistan Steel Mill demerger. The SCCP ordered it. We have a merger committee. I had that committee. I think Khuzam, and we had a discussion on it, heated discussion on it earlier also. What happens is, what they're afraid of is, we have the capacity to look into we go into the ratio, swap ratio and this, and we have auditors and chartered accountants who will go to every extent to see. And what we are looking for when we see a merger or demerger, we're looking for a minority interest in it. We want to see that and that's what, but without spending a single penny, I think, without hearings, we have decided most of the cases at the merger committee. Pakistan Steel Mill was the most complex. The Supreme Court ordered that it should be done in 1 month. It was done in 1 month. So why we have given the authority back to SRO, to the High Courts through an SRO. We had a capacity issue, and we were afraid because normally throughout the world, mergers are normally sanctioned by the courts, except in one jurisdiction. We took this plunge, and we wanted to have the knowledge and also the confidence. Sir, you don't know how afraid we are of the agencies. There is a case against us. There is always a NAB coming and the FIA. This 41B was introduced. I was sitting there, and we had such a problem.
Now you have a judgment of my lord.
Yes,
why should
and this 41B was introduced.
Perform yourself.
I would like
So
to
I say
intervene.
a
I would like to
fear-
intervene.
Yes, sir.
I have been misunderstood perhaps.
Yes, sir.
I didn't wanted this controversy to take this view. I just pointed out that there is a legislation that this is to be exercised by the Commission.
Yes,
And
sir.
by way of a notification, it has been entrusted to the court. So either you take back that section 8 and amend the law and put it back to the courts. But the legislation says that it is to be exercised by the Commission. So if you don't want to do it, then you perhaps ought to amend the law and putting it back to the court, so that Mr. Khudam's worry is also gone.
My
But
lord-
presently it is by way of a notification of a minister.
Yes.
You try to understand, you are misusing, you are treating the courts like your employees. That your minister says that these sections are to be exercised by the judge, company judge. He is so idle sitting, a company judge. We are burdened with thousands and
My lord-
thousands of cases, please. We have 90,000 cases in High Court of Sindh.
My
And
lord-
some 25,000 cases are being dealt with by
My
the
lord,
company
your-
judge.
your suggestion
4
is-
judges sitting on the original side deal with 25,000 suits. Now we have to spare time for a company matter. These people like Ijaz and Mr. Edr Mota, Mr. Edr Waheed, Mr. Jazeb, they come up and wait the entire day in the court to take a reduction order. Kindly try to
lord.
understand this. So if you don't want to, I just pointed out that it is already in the law that you will do it.
Yes, sir.
But
we'll
by
do it.
way of some ministerial work assignment, you have given it to the court. So take it back either way.
ठीक है सर।
I think this symposium has backfired.
नहीं सर, मैंने आपको रियल इशू हैदर मैं ये कह रहा हूँ सर, हमें ये डर था कि इसको स्लोली लेंगे, ग्रेजुअली कैपेसिटी बिल्डिंग करेंगे अपनी भी, So ये एक थोड़ा सा stop है. Sir, please.
Thank you, Ji. Just, you're right. Assalamu alaikum, Ji. I think that there's a very rational suggestion made that there are certain cases which are administrative, right? And they're going to the court. And there are certain cases which will be disputes. And the courts are there for disputes. The courts are not there for administrative managerial work. So maybe the notification could be amended, even though I understand the basis of why a notification can be a little contemptuous. But a notification could be amended to the extent that where there may be a controversy. I mean, this is a suggestion which might actually reduce the burden, but at the same time keep it possible for the certain matters to go before the court. I think that was what the suggestion was.
There's already provision when we were making the law, because आपको पता है जो legislature intent होती है वो मेरे जैसा बंदा बैठा होता लिख रहा होता, उसमें हमने एक provision डाली थी और वो ये already है, and this is why we are discussing it, कि हम jurisdiction अब मिड लेवल मीडियम साइज कंपनीज पे लेके जाते हैं, क्योंकि हमें अभी थोड़ा बहुत कॉन्फिडेंस हो गया है. देयर इज अ देखें सिस्टम डेवलप. वी डिडंट वांट टू डू सुबह एक एक्ट आए और सुबह सारा कुछ रिजीम चेंज हो जाए. तो वी वर टेकिंग स्टेप्स स्लोली, लेकिन अंडरस्टैंड करें कि एससीसीपी दिस इज़ अ न्यू एक्सपीरियंस, दुनिया में इस तरह नहीं है, लेकिन हमने क्या एवोल्यूशन करें. मैंने आपको बताया कि हम पाकिस्तान स्टील मिल जैसे इदारे के डीमर्जर में सक्सेसफुली डन इट. इट हैज़ बीन एक्सेप्टेड. ठीक है, जितनी इर्रेस्पेक्टिव ऑफ द साइज, अगर वो फुली ओन्ड बाय द गवर्नमेंट है तो फिर एससीसीपी खुद कर. जो हमारा बिल्कुल आप सही कह रहे हैं, दिस इज़ द वाई वी आर हियर एंड आई एम वेरी, दिस इज़ ऑल म्यूजिक टू माई. मैंने कहा ये हम सुनना चाहते थे, इट इम्पोर्टेंट अस, इट एम्पावर्स अस टू डू, नाउ गो हेड. हमने प्रोविजन ये डाली भी है कि अगर कोई क्वेश्चन ऑफ लॉ आए या कोई कंटेंशियस मैटर आए तो वी कैन रेफर द मैटर for the Honourable Court to decide the matter on. अगर कोई for example dispute आ जाता है, पार्टी आ जाती है कि ये है, तो सिर्फ उस मैटर का रेफरेंस हम Honourable हाई कोर्ट को कह दें कि जी ये रेफरेंस है, ये कंटेंशन है, इस पे डिसाइड करें.
लेकिन जब कोई मर्जर पिटिशंस हमारे पास आती हैं फ्रॉम द प्राइवेट एंटिटीज कॉर्पोरेट्स, I have never seen any objection to this extent that there is no intricate questions, please refer it back to us, means SECP, so that they may decide. You virtually surrender yourself to the mercy of the High Court. You decided, please save us from the complications.
We can send the Lahore SCCP. Every merger which comes to me is always contested by the SCCP
I'm really looking forward to find one case where I could see that notification.
By sitting with Muzaffar, I'll take his side that we have 117 judges, 5 for High Courts. Indian company cases, ICC, India has 3 volumes of company cases. We have only one CLD, and hardly is 20% taken by us because the entire thing is CCP and the tribunal and all. We have to develop some kind of jurisprudence because India's economy was totally based on, recently an article in Harvard Law Review that Indian company cases, they have 3 volumes of, there's so many company law coming out with every distinction. So maybe sitting with Muzaffar, I'm taking his side. This matter be sent to High Court.
Thank you, my lord. I'm so grateful.
I will never get an audience like this to express my views, so I just want to take this opportunity. I'm talking this like a day-to-day practitioner in trying to consummate commercial transactions. That is my bias, admit it, right? But that is also the engine of the economy in some ways. It is not so much intricate questions of law. There are certain broad principles the courts have set out that in a merger you do not sit as a court of appeal. You have a broad supervisory jurisdiction. You're not going to second guess valuations unless and until there is some definite impropriety shown. These sections are one-window operations in the sense that through sanction I can take care of without rights, reduction of capital, change of name, authorized capital, issuance of shares without cash consideration. These are established principles under that. If I do it in the scheme, I do not need to follow the separate provisions in the Companies Act. Often it happens that the SSCP has a different view. Then I should be available, I should be able to go to the court and say, listen, sir, this is the case law. So it is one window, this is the jurisdiction, this is the remit of the courts, which will now be the SSCP, as to what is the guideline in principle behind which it should sanction or not sanction the scheme. That is very important to us. we think that, the SCCP, if it comes with a
we've got a-
microscope, it will be quite dangerous.
Thank you.